You were here yesterday and you knew we were doing an MTR and you didn't want to come from the jail. So it took us a while to get you to come from the jail. I had to sign an order for you to be brought over from the jail. So the question for you is, do you wish to continue with your plea of not true? Yes or no? All right, state, call your witness in 22 CR 8673 for the offense of injury to an elderly on March 20th, 2023 for a term of 6 years. Is that you?
Yes.
State.
Violated condition number 1, on or about the 9th day of February 2024 in Bexar County, Texas, the defendant, Mariah Lopez, committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
Not true.
Violated condition number 2, on or about the 19th day of January 2024 in Bexar County, Texas, the defendant, Mariah Lopez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
Violated condition number 14G, on or about the 19th day of January 2024 in Bexar County, Texas, the defendant, Mariah Lopez, did then and there fail to register, attend a state-accredited battering, intervention, and prevention program with approved agency in violation of condition number 14G.
How do you plead to that? True or not true?
Not true.
All right. And with regards to the other violations,
Oh, I'm sorry, Judge. We waive and abandon the other violations alleged in the motion.
any objection?
No objection, Your Honor.
All right, state, you can call your first witness.
Your Honor, I call Deputy Casares.
Your Honor, and if I may, before we proceed with testimony, for the purposes of the record, there was a plea offer in this case, and it was against counsel's wishes.
Oh, no. If you are going to put on the record what the plea bargain agreement was.
I wasn't going to put the plea on, Your Honor. I understand you're not allowed to be privy to the plea.
Oh, okay.
Just that there was a plea offer made. I advised my client to take the offer. I thought it was a reasonable offer. There were some cases that were going to be disposed as part of that agreement. Our client has rejected that offer.
Okay. All right. Do you wish to continue with this contested hearing? That's either yes or no. What's going to end up happening is the state has read the violations. You've said they're not true. So now the state is going to call witnesses. They're going to call this first witness. You can turn around. That's the witness at the back of the courtroom. They're going to come and testify. So do you still wish to plead with your pleas of not true? Or do you wish for the state to go forward with their case and call a witness?
I didn't know the rest of it.
A little louder, please.
I didn't know. I didn't know we were doing this. I'm sorry. I didn't.
Well, you were here yesterday and you knew we were doing an MTR and you didn't want to come from the jail. So it took us a while to get you to come from the jail. I had to sign an order for you to be brought over from the jail. So you were brought back today for a contested MTR hearing. What will happen in the hearing is the state is going to call their witnesses. If they present evidence and I find it true, then I will find it true. Then we'll go forward with whether or not I revoke your probation or not. So the question for you is, do you wish to continue with your plea of not true? Yes or no? All right, state, call your witness.
Your Honor, we call Sergeant Casares.
Oh, it's good. Are you?
Yes. Okay. All right. Good afternoon.
Hi, good afternoon.
All right, could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, make sure you keep your voice up so the court reporter can hear. If you can state your name for the record.
Rosemary Casares,
All right, state.
Sergeant, how long have you been with BCSO?
12 years.
And are you a licensed peace officer?
Yes, sir.
As part of your duties, do you recognize what I've marked as States Exhibit 1?
Yes, sir.
And how do you recognize it?
That's a video from our overhead camera there in South Tower booking.
Okay, and how do you, did you have an opportunity to view this?
I did review it, yes, sir.
Okay, and how do you know that you reviewed it?
I signed and dated.
Is this a fair and accurate copy of the recording that you accessed in regards to this case?
Yes, sir.
Okay. Your Honor, I offer States Exhibit 1. This is for the assault.
Okay. No objection, Your Honor.
All right, state's exhibit number 1 is admitted without objection.
Do I have permission to publish this, Your Honor?
Yes.
And so aside from providing the video to the investigations part of BCSO, did you have other interaction with this case?
I interviewed both and I'm in charge of booking, so I'm aware of the inmates that are in our section.
Okay, and so do you recognize the defendant?
Yes, I do.
And how do you recognize him?
She was one of the inmates in booking that day.
Okay, and was she involved in an altercation?
Yes, she was.
And what happened?
She was in line to be transferred to the main jail. She walked away from the line and just went straight to Latrell and started striking her.
Okay, and do you remember the defendant's name? Would it help?
Latrell.
I'm sorry. Would it help if you had to report to?
Oh, okay. Latrell Rebecca.
And that's the victim or the defendant.
Oh, the defendant.
I'm sorry, it's a little confusing. Is that the victim in this case?
No objection to her memory being refreshed while she's
Oh.
holding the document.
All
Your
right.
Honor.
Could you read, and if there's no objection, I believe this is the question.
Judge, my objection is to her memory being refreshed and her reading from her.
All right, if that's a report, you can review it to refresh your memory.
Yeah, just
Okay, so state, what is the question?
who was struck in that video?
Latrell Rebecca.
And who struck?
Oh, he was striking. Oh, Mariah Lopez, I'm sorry.
And what was the date that this happened on?
February 10th, 2024.
Okay, and where did this happen?
South Tower booking.
Okay, and is that in Bexar County, Texas?
Yes, sir.
I pass the witness, Your Honor.
Any questions?
Sergeant, you were present that day at the jail
Yes, sir.
and you have personal knowledge that Miss Lopez assaulted allegedly assaulted that other inmate?
Yes, sir.
And so you don't know that if the other inmate maybe had said something to Miss Lopez to get her, to kind of aggravate her?
She wasn't near her.
So you don't know what their interactions were beforehand, do you?
I do.
Okay. No further questions, Judge.
All right,
No further questions.
is this witness excused or subject for recall?
Excuse from the state, Your Honor.
Right.
Excuse.
All right, thank you. All right, so with regards to the violation of condition number 1, state has already presented evidence on violation of condition number 1. Is there any evidence, and of course, defense, you don't have to present any evidence. Is there any evidence you would like to present on violation of condition number 1?
None, Your Honor.
All right, with regards to violation condition number 1, the court is going to find violation of condition number 1 true. State, are you still proceeding with violations of 2 and 14G?
No, Your Honor, we'll waive those.
Any objection?
No objection, Your Honor.
All right, then the court will hear requests from each party. What would you like to see done with regards to the motion to revoke?
Your Honor, we're asking for the 5 years. The defendant made a bargain for deferred initially. She was unsuccessful on deferred. Her sentence was reformed for community supervision, and she agreed to the 5 years. She didn't do great on community supervision. She picked up a new offense that brought her to the jail. And then once she was in the jail, she picked up another new offense. So, Your Honor, at this time, we're asking for the 5 years.
All right, defense, what are you requesting?
Judge, we're going to defer to the court.
You have no request?
I would allow Miss Lopez to testify. I believe she wants to make some announcements.
All right, you want to raise your right hand? Do you wish to say anything? If you do, you're going to be placed under the oath and you're going to be subject to this examination from the state.
Okay, Your Honor, it looks like at this time the client would not like to testify. Your Honor, we would respectfully request the court to sentence the client to 3 years in TDC.
All right, this is what the court is going to do. The court is going to grant the motion. Court will sentence you to 5 years in the prison. There's an affirmative finding of family violence, credit for any time served, and there's to be no contact with the complainant in this case. And in the assault case, what is the name of the complainant?
Latrell, Your Honor. Sorry. Rebecca Latrell. It's
All right, and there's to be no contact with Rebecca Luttrell.
It's spelled a little unusual.
All right, yes.
Rebecca. Luttrell is Luttrell.
I'm sorry, L-U-T-T.
Luttrell.
All right, and there's to be no contact with Rebecca Luttrell. All right, I'm showing you what's in the certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? All right, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on probation. Do you understand? All right, because this is a felony conviction and because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to. The court is calling 2024 CR 0348 and 2024 CR 1860, State of Texas versus Macedonio Martinez. Could I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Scott McCook from Mr. Martinez.
Are you Mr. Martinez?
Yes, Your Honor.
Counsel, have you received all of the discovery in each cause number and did you review it with your client?
Yes, I have and I did.
And each cause number, the court will find that the state is in compliance with discovery. And each cause number, did you review the documents entitled Application for Community Supervision with your attorney? Did you understand it?
Yes, sir.
And did you sign it?
Yes, Your Honor.
And each cause number, did you review the documents entitled True Bill of Indictment with your attorney? Did you understand them?
Yes, Your Honor.
Counsel, in each cause number, do you waive the reading of the indictment?
Yes, Judge.
State, in each cause number, are you proceeding on the indictment as presented?
Yes, Your Honor. For the family case it is as is, and then for the CTD case, we're proceeding on both counts of the indictment.
Did you review the documents entitled Court Admonishments and Defendant's Waivers of Affidavit and Admonitions with your attorney? Did you understand them? Did you sign them in all the appropriate places?
Yes, sir.
Did you understand and the cause number ending in 48, you're charged with the offense of assault, family choking, strangulation? That's the third degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. And the cause number ending in 60, you're charged in counts 1 and count 2 with cruelty to non-livestock. Did you understand that is also cruelty to non-livestock, torture, etc. Did you understand that each of those cause numbers, in each of those counts, the range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes,
If
Your
y'all
Honor.
will put count 2 on both of those, counts 1 and count 2?
Yes, Your Honor. Would you like me to put it just after the 94 or?
No, if you'll put it after the charge or either above the charge, that way he'll know it's count. Yes, he'll know it's count 1 and count 2.
Absolutely, Judge.
Do you need a break? Okay. And each cause number, do you understand you have a right to jury trial? Oh, I'm so sorry. Do you have the cough drop now? All right.
It gives me time.
Let me see if I have one. I think I mentioned some. Do we have any cough drops over
They're
there?
down there, Judge.
All right, just one moment. Let me grab a cough drop for her.
She might have flower allergies.
No, she's there. Her flower allergies. This one.
I went ahead and hopefully I've done, if that's helpful.
Oh, no, that's good.
Okay, thank you, Judge.
That way, it'll be clear to both parties exactly that he's pleading to both counts.
Yes, ma'am.
And state. All right, we're back on the record. And did you understand, if you have a plea bargain agreement, the court does not have to follow your plea in either of these cases. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Counsel, did you have him sign? Did you understand by entering these agreements you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into pleas in each of these cause numbers?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does.
Do you believe he's currently competent and was legally sane at the time of the offenses?
I do believe.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, punishment is to be assessed at 8 years in the prison. The state recommends community supervision. The cases will run concurrent. State will take in consideration 717751, 723910. There's to be no ownership of connection with animals or pets. And in the cause number ending in 48, there's an affirmative finding of family violence. There's to be no contact with the complainant and no contact with Dominique Hernandez. Did you understand with the affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as a primary custodial parent?
Yes, Your Honor.
Did you understand that to be your plea?
Sir.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
Only bond-related motions, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 8 years. And the cause number ending in 1860, they're requesting a TAP evaluation, follow recommendation, $1,000 fine, 200 hours community service restitution, and that you be placed on the MIC caseload. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then in the cause number ending in 1860, how do you plead to count one?
No contest.
How do you plead to count two?
No contest.
And the cause number ending in 0348, how do you plead?
No contest.
State any evidence.
Yes, Your Honor. For both causes, state wanted attachments with both.
No objection.
Right. State, did you have a chance to speak with the complainant?
Yes,
And is the complainant aware of the plea agreement?
the complainant is aware, Your Honor. Yes.
All right. You may be excused.
Thank you, Judge.
And each of the cause numbers, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. And cause number ending in 0348, the court will find you guilty. And the cause number ending in 1860, the court will find there's sufficient evidence to find you guilty of count 1 and count 2. The court will find you guilty of count 1 and count 2. Is there anything you wish to say on behalf of your client?
Just so you know, Judge, he was going through mental health issues when this occurred and was off his medication. Since then, he's been on a GPS and has on his own gone and had an anger management class that he completed. More importantly, I think, is he is consistently seeing a therapist that can be verified with this pretrial officer because she's allowed him to go to the appointments and also got back on his medication with the doctor. So he's addressing his mental health issues. And so I'm confident that you won't have any issues with him on probation. He's also going to suffer a severe consequence already out of this, even though he's getting probation, and that he's been a licensed insurance adjuster for, I think, going on 20 years. Because of these felony convictions, he's going to lose his license and lose his job. He's confident he can find other work, but he would have preferred not losing these things. So he has suffered consequences because of this, and he's addressing the mental health issues that caused it, if that'll give. the court any comfort in this deal.
Is Child Protective Services involved in this?
No, they're divorced and they're not his biological children.
Okay. Well, why was
He
he,
does have his own children though.
well, in the police report, he's complaining that she has a boyfriend at the child exchange. So what child exchange was taking place?
I don't know, but if it's something that we saw from the police report of that incident, like I said, his mental health wasn't right, but maybe you can answer that.
We never had, the only child exchanges we had were with her ex-husband. And that's how we would do child exchanges. Like I would take them.
No, I mean, your attorney is saying that you don't have any biological children with her.
Oh, no, not with her.
What
All
he's
right.
saying is he would take the children to meet with their father.
Their stepchildren, my
Child
stepchildren.
But they're divorced, so he doesn't have contact with them.
And what is his mental diagnosis?
Anxiety and depression. But I've kept up. I've started off at twice a week for therapy, once a month for psychiatry, and they've tapered me off to once a month for therapy, and then once a month for psychiatry.
Okay, I'm not a psychiatrist. I don't pretend to be one. Did I take a lot of psychology courses in college? Yes. Where I could have majored in it? Yes. But I'm not a psychiatrist. So I don't understand how I'm not on my anxiety or depression medication equals cruelty to animals.
I don't know, Judge.
So if I can explain that, yeah.
Yes.
So on that day, it was a long week. I underestimated my role in the situation where her daughter, my stepdaughter at the time, had a back surgery. And so I thought it was going to be, her and her ex-husband or whatever. So he didn't go. He went for like 2 hours. And so I took the whole week off of work. That was stressing me out. And then when we got back from when she was released from the hospital, I had to go pick up my mom because it was my daughter's time to come live with me for the summer because of my agreements. So I drove back from Laredo, came back, and then we went to the hospital, picked up my stepdaughter, and we all went home together. And then we just started having an argument, and I think both of us were really heated. Then when she left me, I fell asleep because we fought all night and I worked all day and I passed out. I fell asleep. When I woke up, she was gone, and I had lost my family. And so I just kind of I've never had a mental health issue like that, like a mental lapse like that.
So I'm trying to understand how all of those pressures translate to killing a rabbit, and it appears snatching apart the spine of a snake, but you didn't disturb the cats that were your mom's cats. So I don't understand.
Oh.
Who did the snake and the rabbit belong to?
The cats are all of our cats.
All right, so who does the snake and rabbit belong to?
The rabbit was mine and hers, and the snake was her son's.
All right, so you killed the rabbit and you killed the snake. Okay. All right. All right, this is what the court is ordering, and cause number ending in 0348. Court is going to sentence you to 8 years in the prison, suspended and probated for 8 years. This will run concurrent with 2024 CR 1860. Take in consideration 71775, 723910. There's an affirmative finding of family violence. There's to be no contact with Christine Martinez, Dominique Hernandez, no unsupervised contact with minors, regular reporting by Zoom or in person, proof of employment within 30 days, no employment as a home health care provider or with minors. There's to be no ownership or contact with any animals. So that means not going to the zoo, anything that has to do anything with animals. You can't own a goldfish, anything. You understand? I'm going to want field visits one time per month until further notice. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are completed, that will be deemed satisfied. Is there anything else with regards to that case, probation?
No.
Did you? There'll be regular random UAs. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal in that cause number? Did you understand it and did you sign it?
Yes, yeah.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because it's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, next we're going to proceed in cause number ending in 1860. In each count, the court is finding you guilty. Both counts will run concurrent with each other. And it will be concurrent with 2024 CR 0348. Regular reporting by Zoom or in person. Regular random UAs. 200 hours of community service restitution. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Field visits until further notice. No unsupervised contact with minors. There's to be a TAP evaluation, follow all results. There's to be a MIC evaluation, follow all results. And those evaluations are to take place in custody. There's to be no contact with animals. Probation, there's going to be field visits until further notice. Is there anything else you need?
In filling out his personal data form, it indicates he lives in Laredo.
Okay.
So are you giving him permission to?
All right. So what we'll do, because you all can't do field visits in Laredo, correct?
So we can transfer the case. We can transfer the case, and depending on whether or not they have the ability to do that there, I can ask for a report to let you know.
All right. So we'll do a transfer to Laredo. I'm going to want GPS, waive fees, and he's to be on GPS until further notice. Is there anything else, probation?
No, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Sure.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Sure.
And probation, both cases, you can see it, they'll transfer them to Laredo. All right. Thank you, Deputy Lord. He's going to go into custody. All right.
Judges, are you ordering jail time as a condition of probation or what?
I'm ordering that he remain in custody until the TAP evaluation is completed, until the MIC evaluation is completed, and follow all results of the TAP evaluation and MIC evaluation.
He's still got a job at this time, Judge. I mean, could you give him a week to turn himself in or something to make those arrangements with his employer? And
No.
that's gonna hurt his livelihood.
I mean, I understand. All right, thank you. It's 8-4, State of Texas versus Demetric Deshaun Jackson. Can I have parties announced for the record for the state?
Travis, thanks for the same time.
Defense?
Lalo Barraza for the defendant.
All right, you entered a plea on April 19th of no contest, and you applied for probation, and you entered a plea on the offense of assault, family choking, strangulation. Punishments be assessed at a cap of 7 years. The state opposes your application. Have both parties had a chance to review the PSI report, state? Defense?
I have, Your Honor.
All right. State, do you have any witnesses?
State has no witnesses.
Defense, any witnesses?
Just my client, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, state your name for the record.
Demetric Jackson.
All right, you can lower your hand. Defense?
Can you please state your name for the record?
Demetric Jackson.
Okay. Demetric, you've applied for probation in this case, is that correct?
Yes, sir.
Okay. Can you tell the court why you think you should be getting probation?
I'm very deserving of a second chance, and I want to be more helpful to my kids. While it'll help me stay more focused while I'm trying to rebuild what I lost for my kids.
Okay, this was an incident that occurred, and I believe you told me it was purely an accident, correct?
Yes, sir.
Did you have any relationship with this woman?
No, sir.
Wait a minute, I'm sorry.
Okay.
How's an, I mean, he's pled to assault choking, is that correct?
That's correct, Your Honor.
I don't understand how assault choking is accidental.
Are you talking to me?
Yes, I mean, because
Oh,
you're saying it was an
oh.
accident. I don't know how you choke someone accidentally.
Oh, no, it was a misunderstanding. I mean, it was a misunderstanding.
How is choking someone a misunderstanding? And mind you, I'm just trying to figure out what you're trying to tell me.
Yes, ma'am.
So I don't understand how choking someone is an accident or how choking someone is a misunderstanding. Now, if somebody said, choke me, and you thought you heard them say choke me, and then you proceed to choke them, I can understand, oh, that's a misunderstanding. I thought you were telling me to choke you, but you didn't. So I'm trying to figure out where you're coming from.
You're referring to the whole incident, is that correct?
Yes, ma'am.
You're referring to the incident, correct?
Yes, ma'am.
And did you have any kind of relationship with this woman?
No, I didn't.
Okay. How did this come about? Did she feel that she had a relationship with you, or what? Can you explain that to the court?
We was working on a business plan, and I guess our feelings got more in tune. And she was trying to be more than what I was supposed not that more. So
I'm sorry, I can't understand what you're saying.
I said, we was working on a business plan, a business deal, and I guess her feelings got more involved in. She was trying to carry on a relationship in a business relationship with her. So I mean, I feel like she was posting a sign like I
And if the court puts you on probation, how do you think this would help you and help your family?
it allowed me to rebuild what was taken away from me, what was like literally robbed from me. So, you know, it's the steps I have to take. I mean, for me to be out here with my kids, I mean, I'll do whatever I have to take. I mean, I promise my kids that I would give them the remainder of my years. I mean, be dedication to them than what I've given them in the past.
No further question.
So you said that this was all a misunderstanding, and I was reading in the PSI that you also said she did it to herself. Did you recall telling the PSI person that she did the choking to herself?
Yes, I didn't touch it. I mean,
Okay, so it's your position that she choked herself.
yes,
Okay, and you told the TAP evaluation officer that you smoke 8 blunts on a daily basis. Do you recall telling them that?
I used to.
Do you still smoke 8 blunts on a daily basis?
No, sir.
Okay. And do you think you have a drug problem or need drug treatment?
No, sir.
Okay. And have you been on probation before?
Yes, sir.
Have you always completed your probation successfully?
Yes, sir.
Okay, so you've never had to have your probation extended?
I was on probation one time. I don't think so.
You've only been on probation once?
Yeah.
So were you put on probation in 1995 for assault bodily injury?
No, sir.
No?
No, sir.
So if the PSI says that you were, is that correct or incorrect?
Incorrect.
Okay. And you weren't put on probation in 2004 for possession of controlled substance, PG1, 1 to 4 grams?
Question, that's right.
So if the PSI says that, the PSI is wrong.
Yes, sir.
Okay. And you weren't put on probation for driving while your license was suspended in 2000?
Yes.
That was the time you were on probation?
No, it's in 1994.
Okay. So the 2000 for,
I was on parole. I was in prison for parole. I was on parole.
which year did you go to prison?
2006.
But before that, no probation?
No probation.
Okay. So you were never revoked from probation?
No.
Before that? Okay. No further questions, John.
All right, any follow-up question?
No, Your Honor. Rest.
All right, the court will hear argument. State.
Your Honor, I think according to the PSI, he has been on probation many times. He's been revoked from probation many times. I think he's come to the court and he's misrepresented his criminal history. Furthermore, he's minimizing his guilt. He says that he didn't do it. He says it's a misunderstanding. He even told the PSI officer that she choked herself and that any injury she might have had, she caused to herself. I will also point out that to the extent that defense tries to argue he had a rough upbringing, he told the PSI officer that his childhood was blessed and that he doesn't need any kind of drug treatment. He also said he doesn't see how probation is going to help him, but he'll try. I think this is someone who doesn't want probation, doesn't want the kinds of services that are available to help improve somebody's life while they're on probation. And for that reason, the state is asking that you meet the cap at 7 years.
All right, defense.
No, you can't.
All right, if he wants to say something, I'm fine with him saying something.
Don't say so, go ahead.
When he was saying about it wouldn't help me. I was talking about the treatment, the classes, not as for the probation. The lady had called me again yesterday from the PSI, letting me know that she was typing too fast and some of the words got mixed up. And she called me again yesterday and was asking me more questions. Because when I did my PSI, she really wasn't understanding what I was saying. Before, so she typed on the paper.
Okay. All right, defense.
Well, Your Honor, I think this case has been going on for quite a while. He hasn't been in any further trouble, Your Honor. I think this was an incident that occurred because I think the lady thought that she had a relationship with him and he did not want to. We're asking the court to put him on probation. I believe he knows that probation will help him. He'd like to do what he can to get a job, do what he can for his family, and be there for his family. So we're asking the court to place him on probation.
All right. Mr. Jackson, I want you to know, I did look at everything. I just don't think that you're a good candidate for probation. What I'm going to do is find you guilty, and the previous judge found you guilty. Going to sentence you to $500 fine, time and money run concurrent. There's an affirmative finding of family violence. There's to be no contact with Elizabeth Dahl. Take in consideration 2020 CR 2357, and I'll sentence you to 6 years in the prison. Give you credit for any time served. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, Mr. Jackson, if you want, I can ask that you be referred to the therapeutic community. It does not increase the length of time that you're in custody, but it may be able to help you with any drug issues you may have. Do you understand? Would you like that or no?
Yes, I was trying to understand because.
All right, thank you. Good luck to you.
Judge denies Dimitri Jackson's application for probation and sentences him to 6 years in prison with a $500 fine, an affirmative finding of family violence, credit for time served, and no contact with the victim.
Court is calling 2023 CR 9045W and 2022 CR 10906W. State of Texas versus Adriana Harrison. Can I have parties announced for the record for the state?
On Shirley Nelson for the state.
Denny Callahan, defense.
Are you Miss Harrison?
Yes, ma'am.
All right, we were here previously and the court informed both parties that I would not be accepting the plea bargain agreement. It's the court's understanding that you all have reached a new agreement. Is that correct?
Yes, Your Honor.
All right. We're going to proceed first in cause number 2023 CR 9045W. Counsel, have you received all the discovery in that case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Harrison, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Harrison, I'm going to show you what's entitled Court Admonishments. Well, let me backtrack. Ms. Harrison, this case was not indicted, although I know the rights and waivers have been tendered to you. I'm going to go over those again. Do you understand you have a right to have the grand jury hear any evidence in this case and make a decision on whether or not to indict?
Yes, ma'am.
Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
Did you understand your attorney has certain rights, namely 2 days from the presentation from the information and 10 days from the presentation of the information to prepare for trial?
Yes, ma'am.
Did you understand that by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
And did you review the information with your attorney and did you understand it?
Yes, ma'am.
And counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Your Honor.
Going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Okay. Did you understand you're charged with the offense of aggravated? I'm sorry, you all don't talk behind the court reporter. Right here, excuse me.
Mr. Meadows. Mr. Meadows.
Thank you. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Harrison, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, you're to be sentenced to 5 years in the prison. There's an affirmative finding of deadly weapon. There are no applications. The state will take in consideration 2023 CR 10983. Is it everyone's intention that this case, if I follow the agreement, is to run concurrent with the probation case?
Yes, Your Honor.
And then it will be concurrent with cause number 2022 CR 10906W. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes.
Showing you the waiver of repeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Oh, Your Honor.
And also, is this a family violence case?
It is a family violence.
All right, did you understand if the court, from reading the stipulations or any evidence that's presented, if I determine that this is a family violence case, then I will enter an affirmative finding of family violence. Did you understand that?
Yes, ma'am.
And did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
And did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
All right. All right, then to the offense as charged, how do you plead? Guilty, not guilty, or no
No
contest?
contest.
State any evidence?
State offers states exhibit 1 of the attachments.
Any objections?
Oh, sorry, Judge. No objections.
No, you're offering states exhibits 1 and attachments?
Yes, Judge. It's been a long day.
No problem. Any objections?
Objection,
All
Your Honor.
right. Ms. Harrison, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Pursuant to our agreement, Your Honor, Ms. Harrison has a right to ask you to bend the plea agreement and give her, or rather reinstate her probation. And that support thereof in the PSI, it shows that they say she didn't have a mental health or didn't take mental health treatment because she attempted suicide, but she did. I want to make that correction. In her hand are 2 completions of self-rehabilitative efforts in the jail of family violence. But she has a right to ask that outside of the agreement of 5 years. I asked the court to follow the agreement, but perhaps to consider taking both cases and putting her back on probation. Lastly, her mother's here in court and supports her. That's a good sign because of her past. She still has not thrown in the towel for her daughter. Do you want to talk to the judge?
Yes, sir.
All right, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Adriana Harrison.
All right, defense.
May she make a narrative statement, Your Honor?
State, do you have any objections to the narrative?
No objection.
All right.
I just want to say I apologize for my action. I just want to say I apologize for my action on my behalf of my daughter. I owe her a deep apology for acting the way I acted. And just to say sorry to you for ending backing up in front of you, Judge, and for you to please give me another chance.
All right, what's your daughter's name?
Ariana.
Okay.
I don't
Nothing further, Your Honor.
All right, anything from the state?
No, Judge.
All right. You want to explain that to me?
I'm just trying to get my daughter back.
No, why do you have a knife in your hand?
Explaining this.
And how old is your daughter?
She just turned 2.
All right, so do you realize that your daughter remembers you with a knife in your hand?
Yes, ma'am.
You need to work on your anger issues because this isn't the first time that you've been to this court for anger issues. And I know your mom says, well, would probably say, oh, she needs help with her mental health or she needs help with her drug issues. That's what I was giving you when you were on probation for that, and you didn't take advantage of it. You just doing whatever you want to do. So I don't know where your anger issues stem from, but you need to get those under control because otherwise, you know what's going to end up happening? You're going to end up being a habitual. You know what that means in Texas?
Yes, ma'am.
That means if you pick up another felony, depending on the type of felony, your minimum is 25 years in prison.
Yes, ma'am.
And then if you go to prison for 25 years, when you come out, your child will be an adult. Hopefully your child will not be before a judge with a defense attorney saying, oh, my mom pulled out a knife when I was 2 years old and I was there to witness it and she was being violent to her girlfriend and she went to prison, so I didn't have anybody to raise me. That's what's called the cycle, and that's what ends up happening when you do these things.
Yes, ma'am.
All right, the court will follow your agreement, sentence you to 5 years in the prison. There's an affirmative finding of deadly weapon. There's going to be an affirmative finding of family violence. Take in consideration 2023 CR 10983. This will run concurrent with 2022 CR 1090W. There's to be no contact with Diamond, Dyamond Jones, Dylan Angelus, Dylanangeles, and there's to be no unsupervised contact with minors. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Could you pass that, please? Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because it's a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we're going to move on to 2022 CR 10906W. I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Adriana Kisna Harrison who was placed on deferred adjudication in 2022 CR 10906W for the offense of continuous violence against family on November 5th, 2022 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1, on or about the 6th day of September 2023 in Bexar County, Texas, the defendant, Adriana Kisna Harrison, committed the offense of aggravated assault with a deadly weapon in violation of condition number 1.
How do you plead to that? True or not true?
The state waives and abandons all remaining alleged violations.
Any objections?
No objection.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
With Your Honor, we would ask that you revoke probation at this time, that the defendant be sentenced to 5 years in TDC, and that it run concurrent with her other aggravated assault with a deadly weapon, which you just sentenced.
All right, is that the agreement?
Yes, Your Honor, pursuant to the agreement, she's permitted to ask you to ignore it and put her back on probation, nothing further.
All right. Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, then the court will follow your agreement. The court will grant the motion, find you guilty, revoke sentence you to 5 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with, I think it's Taquidra, Taquuiedra Evans. There should be no unsupervised contact with minors. And I'm sorry, what was the cause number for the other case? Does anybody know offhand? Yes.
2023 CR 9045W.
And it's to run concurrent with 2023 CR 9045W. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence and a conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. You're going to have to do better. And obviously, you should not be in any relationship with anyone until you get your life together. And you should not be in a child's life until you get your life together, because children learn by what they see and what they hear. When you see a child who's using profanity and they're young, they didn't just like all of a sudden start using profanity. The people around them use profanity. And when you have a child who sees violence in their life, they start thinking that's the way you solve problems, by using violence. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
You're welcome. Court is calling 2023 CR 6843, State of Texas versus Latasha Jenkins. Can I have parties announced for the record for the state?
Seal Landers for the state.
Defense?
Rafael Leal for Natasha Jenkins.
And are you Ms. Jenkins?
Yes, ma'am.
You entered a plea of no contest on December 5th. According to the plea bargain agreement, the state is silent on your application. They're taking in consideration 2022 CR 3280. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
Defense, any witnesses?
Yes, Your Honor. I call Andre Carruthers to stand.
All right. Carruthers? Deputy Laura, we have a witness. All right, Mr. Carruthers, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Andre Carruthers.
All right, defense?
Yes, Your Honor. How do you spell your last name?
Corrothers.
And what is the type of your relationship to Latasha Jenkins?
My boyfriend.
Right? And are you the complainant in this case?
Yes, sir.
And, and this is the incident that occurred May 5th, 2023, is that correct?
Yes, sir.
Okay, and you understand the accusation and the offense that Ms.
Oh, just 1
Jenkins.
second, off the record for a moment. Excuse me. If y'all could move down to this end. All right, you may continue, counsel.
Thank you. And you know the charge that Ms. Jenkins is facing?
Yes, sir.
Okay, and it's an aggravated assault with a deadly weapon.
Yes, sir.
And she has applied for the full adjudication, which means a type of probation that there will be no conviction if she follows the guidelines and does not commit any other offenses or comes out positive with drugs.
Yes, sir.
You understand that?
Yes, sir.
And are you opposed to Ms. Jenkins getting probation?
Am I against it?
Are you against it?
No, sir.
Okay. So you're in support of that?
Yes, sir.
And There is also a provision perhaps that the court may impose that there will be no contact with you if she's granted probation. Are you aware of that?
Yes, I was told.
And do you oppose, the contact order?
Yeah.
And, do you oppose no injurious or hazardous contact? Are you in favor of that? Which means
Yes.
the two of you or she cannot have or give you any kind of, injury or
Yes,
be a hazard to your health.
Yes, sir.
You think that that would be okay with you?
Yes, sir.
Okay. And, concerning the incident, was it, what type of injury did you receive?
It was like a scratch.
Scratch?
It was like a scratch.
So there was nothing else besides that? Okay. And, were you two, on drugs at the time?
Yes, sir.
What type of drugs were you doing?
Yeah.
And, she cannot be having, if you two are in contact with each other, she cannot be having or be using drugs.
Exactly.
Would you be able to support that, even that you're also a drug user?
Yes.
Are you still using
Against
drugs?
it. No, sir.
I'm sorry, I can't hear you.
Are you still using drugs? Yes or no?
No, ma'am. Oh, no, ma'am.
All right, that's the way to do it.
All right, any questions?
No question, Chairman.
All right, so I see here that she stabbed your bag several times. No. According to the police report, it says that she started cutting up your bag.
Did I know?
Okay. All right, thank you.
I call Natasha Jenkins to stand.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Sure.
All right, you can lower your hand, state your name for the record.
Natasha Jenkins.
All right, defense?
Ms. Jenkins, you applied for a type of probation known as deferred adjudication probation, is that correct?
Yes.
And that is a type of probation that if you do not comply with the requirements of that community supervision, deferred adjudication, the judge has, the full range, if you violate a condition, the full range of punishment, anywhere from, as low as 2 or up to 20 years. Are you aware of that?
Yes.
Okay, do you intend to abide by the conditions of probation that the court may impose?
Yes, sir.
And why do you think that is the case?
Because I'm changing I sat in Bear County for almost a year and I completed successfully classes, got certificates. I got, recommendations from the teachers and, unlock programs for the outside community, to better be successful with mental health and my, substance abuse and me, period.
And the programs that you completed, are those included in, Defense Exhibit 1? Central? Do you recognize Exhibit 1?
Yes, sir.
And Exhibit 1 consists of 8 pages of certificates covering, the different programs that you've done.
Yes, sir.
And that includes anger management, is that correct?
Yes, sir.
And also, therapy groups
Yes, sir.
and Microsoft Word
Yes, sir.
and Excel
Yes, sir.
and exhibit number 2, what is that?
The letter to the judge Boyd, from Lisa Rodriguez, the unlock program.
Okay, and what type of program is the unlock program?
They go through any classes that you need, that the court orders for you. They help you with the fees. It's for continuing care. It's a reentry program. They help you with anything that you need, to help me get back on my SSI, get my SSI started again. And to get me with a part-time job, whatever SSI allows me to, work outside of SSI.
In few words, is that they help you to reintegrate yourself to society?
Yes.
Okay. I offered Exhibit 1 and Exhibit 2 for.
Any objection?
No, Your Honor. State has reviewed these.
All right, then Defense Exhibit 1. And Defense Exhibit number 2 is admitted into evidence.
Now, prior to this incident, were you on SSI?
Yes.
And were you also working part-time?
Yes.
And what do you intend to do, or what are your plans if the judge were to grant you a deferred detention?
Get back on my SSI and continue a part-time job, that SSI allowed you to work and maintain my mental health.
What type of mental health illness do you suffer from?
Bipolar and PTSD.
And were you on medication at the time of this incident?
No.
Okay, and are you on medication now?
Yes.
Okay. And do you have a place to stay
Yes.
if you were granted probation?
Yes.
And where would that be?
My brother's house.
And does he know that that's what you're planning to live?
Yes, he's been supportive for me since I've been in the American.
Okay. Do you have any children?
No.
Any questions?
No, Your Honor.
All right, why did you cut your boyfriend with a knife?
We were into an altercation and I didn't intentionally do it. When I like pulled it out, it was like a scratch that was gone like within maybe minutes.
All right, why were you cutting up his bag?
I don't remember cutting his bag up. I don't remember that at all, cutting the bag.
All right. Why have you not been successful on previous probations? Because I see that you've been on probation in
Yes,
Des Moines, Iowa.
Yes. I was in Des Moines, Iowa. My mother died. My husband went to federal prison. My brother left state. I was the only one there. I had no support system there. And I was like going house to house. I like couldn't maintain employment.
What is the escape?
Oh, it wasn't escape. It was dropped from escape. I left from the place that they sent me to after I got out of jail. It was a involuntary absence. That's what they dropped it.
No, and where did they place you after you were released from custody?
It was like a halfway house.
Okay, and you left without permission?
On Sunday.
Yeah, and then, so that's from 2007, and then 2011, you were placed on probation again and revoked, and all of this is out of Des Moines, Iowa.
Yes.
Then in Knoxville, Illinois, you were revoked from probation there as well.
Knoxville, Iowa.
No, it says Knoxville, Illinois, Marion County.
Yeah, that's Iowa.
Okay. And then Hamilton County, Illinois.
Iowa. I don't know why they put Illinois.
Okay. All right. And then Dallas County.
Yeah, that's Iowa too. Iowa was just a bad area. Since I left there, I have been so much better. Like I was like, my life was not great there at all. I had no support there. Like I said, like my mother died, my brother left town, my husband went to federal prison. My life was just not great there. That's why I left there and came up here and lived.
All right.
And started my life.
I've read, defense, I've read all your exhibits and I've read your letter, from Ms. Rodriguez. I appreciate you, presenting these to me because it gives me a chance to know the person that's before me. And I also am taking in consideration the testimony of Mr. Carruthers. However, I don't think you'll be a good candidate for probation. So I'm going to find you guilty. There's to be no contact with Andre Carruthers, Tiffany Sansom, SANSOM. There's affirmative finding of family violence, taking in consideration 2022 CR 3280. I'll sentence you to 3 years in the prison, give you credit for any time served. I've actually given you less than what was requested. And there's also an affirmative finding of a deadly weapon. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I've actually given you less than what you bargained for, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence and also an affirmative finding of deadly weapon and a conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Ms. Jenkins, good luck to you, okay?
And, is it possible if I get my 2 for 1?
You'll have to, here's what people don't understand. 2 for 1, 3 for 1. The court is not in charge with that. It's whatever institution you're at, they're in charge of what credit they give you. What I can tell you, you will at least be receiving time for every day that you've been in jail. And whether they want to give you good time credit or not, that's dependent on the institution. But if there's an issue, for example, let's say hypothetically, you've been in jail for 50 days. If you feel like you're not getting credit for those entire 50 days, then your attorney can come back. But if you want 100 days or 150 days, that's something with the institution. It's not something that I can give you. All right, good luck to you.
I underestimated my role in SIT. And just like that, the curtain falls on a pair of defendants who learned the hard way that excuses don't hold up under a judge's spotlight. From trying to dodge a jail transport to blaming an animal cruelty charge on missing a therapy session, accountability always finds a way. Justice does not always move fast, but when it moves like that.